the election manual that we showed you also said that the entire election will occur in 42 days. And we want you to hear that from the horse's own mouth. So there's 15 days to hear the witnesses, and then the witness statement, the cross-examination. There's another 15 days to hear the respondent, and after that, the court has 42 days to give the ruling. So 42 days from the date of the signing of the filing of the petition. If the petition is filed tomorrow, which will be 30th of December, we have counted 42 days to end on the 9th of February. Just a few days before Valentine, the Supreme Court will give its ruling on this petition that will be filed tomorrow. So why will the petition be heard in 42 days? Is that a reasonable time? Could the lawyers challenge that? We put the question to Supreme Court Judge Younni Kulendi, and this is what he had to say. We also asked Mr. Kulendi how many judges will be empaneled for the election petition. And this interview was recorded before the election occurred, and we're just looking at possibilities of what may happen in the future. But here we are today. It has become a very, very relevant interview. This is Justice Kulendi speaking to me before election about the 42 days duration stipulated for election petition. But we're hearing something about 42 days, which was the big story out of the launch of the book. The election petition will now be started and finished in 42 days.
Correct. Correct, because I did say that one of the things that has informed Parliament, first of all, to revise the rules of engagement is our experience. So it's obvious that if we take a cue from the last election that ended up in a dispute, and we take into account the fact that for almost 9 solid months, every Ghanaian, wherever they found themselves, when their circumstances allowed, was glued to a TV or tuning into news and trying to find out where are we, what is happening, the pink sheet stories and all of that. That was a lot of lost prime time for country. And I guess that for young people like this who are in a hurry, okay, you hire a CEO, you want to put the CEO immediately to work and get the CEO addressing the urgent matters that affect our lives. You don't want that process hijacked in litigation. And in the way that our courts work, our system is adversarial. And so there are all manner of ways in which you can traditionally drag out and prolong litigation. What Parliament did, taking a cue from what happened in the 2012 election dispute, was then to specifically by legislation provide time frames from the time that the results of the elections are declared. There's a time within which if you have a problem, you must step into court. When you step into court, as with every other process in litigation, but here the law is then specific, you must comply with all the various processes of delivering your paperwork, delivering your submissions, all the way up to the time the parties each lay their cases before the court. And then the law actually requires even the court itself to evaluate and conclude the matter and deliver a judgment within a certain time period so that we can put it behind us and move on as a country with the business of building.
So this 42 days is a new sort of time frame.
It is, and I guess it was informed by the experience. All of lawmaking, constitution making, parliament legislation is always informed by experience. Yeah. You have a border, you have something that weighs down on country wants to address it, and then you use law as the means of engineering it. So in other that we're not caught in another time drain in the unlikely event that there is a dispute. Nobody can tell that there will be one. It's only the protagonists who will know what is going on in their heads. But we hope that they don't take us to another dispute. But if there's ever one, the law requires, and this is not a decision of the Supreme Court, it's a decision of Parliament by law that requires the court to begin and complete the process in that period.
When does the process start? When should people who want to challenge the election petition, when should they start?
It kicks in the timeline, and it's all
in the book.
In the book. Okay, and one of the things that I'm determined to do, and I guess that will be the tango between Paul and I, you're not going to get any specific, concrete, exact opinions from me on any question.
Absolutely.
What I will do is show you where to find the answer. So the answer is in this book. This book tells you when the process starts. But I guess with every other thing, the course of action will accrue from the moment you become aware of the outcome against which that you find objectionable. So it will be from the declaration of the results, so to speak. But this may be the first and last opinion I'll give you. Just in case tomorrow there's one, and then I want to reserve.
I guess it's also in the book, but just before I go to the audience, how many judges will sit at the first instance? The last time we saw 9.
Right.
How many judges? Is it in the book?
It is in the book to the extent that this book harmonizes every constitutional provision that directly affects pre-election, so right from demarcation of constituencies to qualification, eligibility, and registration to vote, to register as a voter, the processes of registration, how the EC conducts those processes, who can register, who cannot register, where you can register, where you cannot register. Then the voting process itself, counting, declaration of results, and then post-declaration of results. It's all in the book.
Okay. There's another question, I'm guessing that's also in the book, but that's important for young people. Whilst the petition, if there's a petition, whilst it goes on, will the winner be sworn in on 7 January? Because 7 January comes before the 42 days. Will the winner be sworn in? We've got confused because in other countries, we saw that, like in Kenya, the swearing in doesn't happen, but in the election petition in Ghana the last time, the swearing in was done. Is it, what is the situation?
Well, you have answered yourself. There's always a precedent. So you go to an election. Now, when you go to an election, the election is declared by the constitutional body mandated by law, by the Constitution, to determine who wins. So the EC declares Paul Adom-Otchere as winner of the election. You are then the winner of the election until the contrary is proved or established. And what is the contrary? The contrary is Younni Kulendi, who says, no, I'm the one who won the election. I then will go to court seeking a declaration that I am the winner and not you. But until that contrary position is proven and affirmed by a court, there is a winner. And because the business of the state is not business that can wait, even for 2 days, let alone 42 days, the business of the state will continue. Because once you are declared by the EC as the winner, you are the winner until anybody or group of people who say, no, you are not. It is someone else. Makes that case, proves that case, and that case finds favor with the court vested with jurisdiction so to do.
Okay, thank you very much. Another round of applause for our interview.